Hi, I am Abhilasha Nautiyal and I practice intellectual property law before the Delhi High Court. Today we will talk about the module on remedies in trademark law. In this module, we will discuss both civil, criminal remedies that are available to a right holder. In addition to these, we will also briefly touch on border enforcement mechanisms that are available to a right holder. We will now start with civil remedies that are available to a right holder. Section 135 of the Trademarks Act lists down the kind of remedies that are available. It first talks of an injunction. The second remedy is damages. Third is accounts of profit. Fourth is delivery up. In addition to these reliefs, Section 135 talks of ex parte injunctions or other interlocutory orders for three reliefs. These reliefs include discovery of documents, search and seizure preservation orders, and restraining the defendant from disposing of assets. Now, these three interim reliefs also have unique names. The first, discovery of documents, is also known as a Norwick Pharmacal order in certain cases, especially when discovery is sought from parties that are actually not pleaded in the suit. The second interim relief for preservation and search and seizure orders are known as ante-pillar orders. And the third interim relief, which talks of freezing the defendant's assets, are known as Mariva injunctions. We will get to the interim injunction and the other interlocutory reliefs in a bit, but before we get there, we will start with permanent reliefs that a right holder may explore. We will start with injunctions. Now, injunctions are court orders that may direct a party to do something or not to do something. An order that directs a party not to do something is known as a prohibitory injunction, and an order that directs a party to do something is known as a mandatory injunction. Let's understand this by way of an example. Let's take the example of Nike and its swoosh logo. Tomorrow, if there is a party, say a party by the name M Brands, who is making counterfeits of Nike products and is misusing the swoosh logo. In such a case, what reliefs do you think is Nike looking at? It is of course looking to stop this party from doing something. And one of the reliefs that Nike would claim is a prohibitory injunction. The second kind of relief that right holders seek is damages. Now, damages are essentially fall in two broad categories: compensatory damages and punitive damages. We will first talk about compensatory damages. Compensatory damages basically try to put the plaintiff in the position that it was had the defendant not engaged in the infringing activities. Now, compensatory damages are the kind of damages that try to make the plaintiff whole again. By this I mean that the plaintiff is compensated for the losses that it has suffered due to the defendant's activities. There are at least three ways of calculating compensatory damages. First is that the plaintiff may assert and quantify the loss it has suffered due to the infringing activities of the defendants. Please remember that the quantum here is directly related to the infringing activities and not other activities that the parties may engage into. The second way of quantifying compensatory damages is based on the profits made by the defendant. Interestingly, this concept of profits of the defendant is also known as rendition of accounts, to which we will get in a bit. The third way of calculating compensatory damages is on the basis of a reasonable royalty. Now, a reasonable royalty test is one where it is seen that what would in ordinary circumstances be the royalty, that if the defendant were a willing licensee of the plaintiff's rights, what would be the amount that the defendant would actually pay the plaintiff as a royalty. We will now talk about punitive damages. Punitive damages are in addition to compensatory damages and are awarded to deter the infringing acts of a defendant. punitive damages are most commonly awarded against habitual and repeated offenders. In the case of Time versus Lokesh Srivastav and another, the Delhi High Court elaborated on the concept of punitive damages and explained the difference between both compensatory and punitive damages. Now, in this case, Time magazine had sued a party in India for infringement of its logos, which were both Time, Time Asia and the red border of the Time magazine. The court held the award of compensatory damages to a plaintiff is aimed at compensating him for the loss suffered by him, whereas punitive damages are aimed at deterring a wrongdoer and the like-minded from indulging in such lawful activities. Whenever an action has criminal propensity, also the punitive damages are clearly called for. Therefore, punitive damages are awarded to set a standard to deter people from engaging in activities that the court wants to discourage. Now, under section 135 of the Trademarks Act, on the one hand, it does list out the reliefs that a party is entitled to, and on the other hand, it lists out certain exceptions to some of these reliefs. Section 135 clause 3 of the Trademarks Act provides exceptions to damages. It lists a few cases where damages may not be awarded to the right holder, even where the right holder is able to prove that the defendant has violated its trademark rights. Now, these cases include cases of infringement of a certification mark or a collective mark, or where the defendant is able to prove that infringement or passing off was not willful. Now, what do we mean by willful? Here, the defendant will have to satisfy at least two things. A, that the defendant was not aware or had no reasonable grounds to believe that it was violating the plaintiff's rights. B, as soon as the defendant became aware of the plaintiff's rights, it ceased use of the plaintiff's trademarks. Please remember that both of these factors have to be satisfied before the defendant can plead that it should not be liable for damages on account of its conduct. We will now come to the next relief, which is account of profit. We had briefly touched on this relief in our discussion on compensatory damages. You may recall that compensatory damages try to make the plaintiff whole, and we discussed at least three ways of doing that. First was plaintiff's losses suffered due to the acts of the defendant. We also discussed a reasonable royalty model. And the third factor that we discussed was the profits of the defendant. Accounts of profit refers to the last factor. When a defendant is violating the plaintiff's trademark, it generates revenue by such use, and it is believed that the revenue generated by the defendant from its infringing activities is actually attributable to the plaintiff. And hence, the plaintiff is entitled to the accounts of profits of the defendant, which the defendant should produce, and the plaintiff may recover the same. In certain cases, at least in the Trademarks Act, you would have noticed the word or between the reliefs, damages and accounts of profits. A plaintiff has to elect between these two reliefs. The reason for this election is that most commonly, there would be a complete overlap between the plaintiff's losses and the defendant's profits. Because there is a complete overlap, a plaintiff should not be entitled to recover twice the amount than what it is actually entitled to, hence the election. However, it may be noted that in some cases there may not be a complete overlap. What about loss to intangible value of a trademark that may be a result of the defendant's activities? Now, in such cases, there may not be a complete overlap between the plaintiff's loss and the defendant's profits. We will now talk of cases where defendants do not enter appearance before court. What happens then? Let's go back to a Nike example. Nike files a lawsuit for trademark infringement and passing off against a party that's counterfeiting its swoosh. The court issues notice to the defendant, but the defendant never shows up in court. can Nike still recover damages? What is the basis for Nike to recover damages where the defendant has evaded court service? Now, courts have taken serious cognizance of such acts. In the case of Microsoft Corporation versus Rajendra Pawar, the Delhi High Court said, perhaps it has now become a trend of sorts, especially in matters pertaining to passing off, for the defendant party to evade court proceedings in a systematic attempt to jettison the relief sought by the plaintiff. Such flagrancy of the defendant's conduct is strictly deprecatory, and those who recklessly indulge in such shenanigans must do so at their peril. So, courts are increasingly granting punitive and compensatory damages even in cases where the defendants are not forthcoming with appearing in court or cooperating in the proceedings.